Welcome to another episode of Legal Stories, where we break down complex legal cases into easy-to-understand content. The case we'll be discussing centers on D-Lite cereal, a product marketed as suitable for infants from 6 months onward, and a legal dispute over whether it could be advertised to the public. In this case, the plaintiff, the manufacturer of D-Lite cereal, sought an interim injunction to prevent the local authority, referred to as the first defendant, from interfering with its advertising campaign. The central question is whether D-Lite cereal qualifies as a breast milk substitute under public health regulations, which would restrict its advertising. But before we dive into the details, let's quickly refresh what an interim injunction is. It's a temporary order granted by the court to maintain the status quo until the court makes a final decision. But what are the legal principles behind granting such an injunction? As highlighted in this case, an interim injunction is typically sought to prevent a party from acting in a way that may cause harm until the court fully resolves the issue. The famous case of American Cyanamide Company versus Ethicon Limited sets out the guiding principles. The court must first consider whether there is a serious issue to be tried. The applicant must show that damages would not be an adequate remedy if the injunction were refused. The court weighs the balance of convenience. The plaintiff argued that the first defendant's interference, specifically by directing local TV stations to halt the advertisement of D-Lite cereal, caused consumers to believe the product was unfit for babies, leading to a drastic drop in sales. The plaintiff wanted the court to restrain the defendant from further interference through an interim injunction, claiming that the local authorities' actions were baseless and causing irreparable harm to its business. On the other hand, the first defendant argued that D-Lite cereal is indeed a breast milk substitute, and under the Food and Drug Marketing of Breast Milk Substitutes regulations, the advertisement of breast milk substitutes is strictly regulated to protect public health. The defendant explained that the packaging of D-Lite cereal clearly showed it was meant for infants from 6 months onward, which placed it under the definition of a breast milk substitute. Statutory Instrument No. 48 of 2006 was enacted to promote and protect breastfeeding, regulating the marketing of breast milk substitutes and similar products. The defendant maintained that their actions were justified under this regulation. The court ultimately refused to grant the interim injunction sought by the plaintiff. The reasons were as follows. 1. The court found that the plaintiff's losses could be compensated with damages if they were successful at trial. 2. The court noted that whether D-Lite cereal was indeed a breast milk substitute would be the key issue at trial, but the prospects of the plaintiff succeeding were not clear enough at this stage to warrant an injunction. 3. The court weighed the potential harm to the plaintiff against the public health concerns raised by the defendant. The court's decision also highlighted the importance of judicial precedent. This mirrors what we've discussed in a previous episode about the role of judicial precedent in maintaining consistency and fairness in legal decisions. In this case, the court also declined to take judicial notice of the plaintiff's assertion that the local authority couldn't afford to pay damages. Lessons learned and considerations for applying for an interim injunction. 1. Your case must involve a substantial legal question. 2. You must prove that harm can't be compensated by money. 3. Show that your harm outweighs any potential harm to others or the public. 4. Unsupported claims won't be considered. This case serves as a reminder of the legal challenges businesses must overcome when seeking court orders that restrict the actions of public bodies, especially when public health regulations are involved. Thank you for tuning in to Legal Stories. Don't forget to follow us on all our social media platforms.